And she's also the co-chairperson of IMC Navi Mumbai and the founder at MentorMyBoard. She's also been the fellow member of the Institute of Company Secretaries of India and holds a Bachelor of Commerce degree. She's a founder of DSM MCO and possesses more than 16 years of an experience, out of which 12 years of practicing as a company secretary. So without any further ado, I would like to welcome our next mentor, Ms. Divya Momaya, with us with a big round of applause.
Thank you. Thank you so much. And this is the first time we are interacting. Thank you, Karan, for inviting. And before we start, because I would like to understand, what kind of journey or at what stage of startup you all are currently. So if I can start with...
I think we can ask everybody to do a self-introduction.
Please, introduce yourself in around 30-second time. So, and what stage of startup you are at currently, so that I will be, able to navigate my discussion on the topic, which will really benefit you.
Hi Divya. My name is King, and I represent What Is My Goal startup. The problem statement what we're working on is helping students to choose the right career choices. We are in early traction. We have an MVP, and we are working with around 400 students as of now. And here are the teammates. I'll ask Shimura to go ahead.
Hi Divya, I'm from the same team as Vignan Joseph here. So we are working with What Is My Goal, and our problem statement is the same. So we are working towards helping guide students towards making career choices that they will be happy in for a long time. Nice. Chitrali and Commander Vikas are also from our team. Please go ahead, Chitrali. Okay.
Yeah, so I'm also from the same team, and we are working on the same problem statement. And even Vikas is from our team.
Okay, wonderful. So, Vikas, I would like you to, let me know at what stage your startup is. Have you created the structure? Because if I'm going to speak with what you have already crossed the journey, that will not make sense. So I can navigate my discussion accordingly.
Divya ma'am, I'm Commander Vikas. I've served the Navy for 21 and a half years. And whilst working with one startup, I could raise $20 million. And this is my second startup I'm working for. And we are a team of 5 people. So this is what our structure is all about. So you know that there is no structure. Right now, only 5 of us are actually handling everything, whatever is possible. So you may take us as a very early startup who is at the the learning stage and who are at the struggling stage, whatever you call it, and you take us from that level, and you can explain us whatever you want. Because I would like to take maximum from you what you know, ma'am.
Sure. So what I understand is you all belong to the same team, same company. And it will be really easy, for us also to help you exactly. So in between the presentation also, if anybody has any question, I would be happy to answer them in there. That will, resolve your doubts and clarify your doubts then and there. So I'll share my screen. You already have been, into the brainstorming stage, what I understand, from you all. And we'll straight away go into the types of the business structures. Now, we all know that sole proprietor, one-person company, partnership, these all are some of the stages of, the business. But when we call this startup usually is recognized by DPIIT, and which is of 2 types. One is the limited liability partnership, or which is the private limited company. Now, because we are talking of this scale, because we are talking of, creating the bigger impact and also making the startup ready for funding, the private limited structure, usually goes best when it comes to the creating the complete structure for the investors to come in. Now, any startup, has different stages. And today, when we see the sustainable corporate, what is sustainable corporate? Today, for example, Reliance, Tata's, these all have reached that stage. Infosys, for that matter. But in 1984, Infosys was Infosys Private Limited, which was, a small company. Today, we have probably after 2014, the startup momentum has gone up. But before that also, when the businesses were at the initial stage, when the founders had a very small team, they were called, the initial businesses, but startup is the name which has come very recently. So it's a long journey wherein you start from the early age. There are a lot of barriers which keep coming, and then once you start overcoming all those challenges, that's where the big corporate, I mean, when you build team, so this entire journey is again a journey of a startup. So without going into the sole proprietorship, partnership, because that's not what we will be looking at today as far as compliance is concerned, because 1 hour Karan has given me, and in that 1 hour I have to cover a lot. So I'll take you very briefly overall, but in case if you have any doubt, please you can ask me then and there. So when we talk of the private limited company, limited liability partnership is a traditional partnership and a combination of a private limited company which gives them a corporate status. But if you want to get registered in DPIIT, as well as you want to avail the 3 years exemption which comes for the tax exemption, then mandatorily you need to be a private limited company. And then there are additional stages of once the company is private, once the shareholders crosses 200, or the company decides to go and raise funds from public, they will convert their company to public limited. And once they get listed on the stock exchange, they are called the listed companies. So if I give you the rough statistics, we have close to 7,500 or 8,000 listed companies, whereas last statistics of MCS shows that we have 30 lakh corporates. At the same time, we have close to 6-7 crore of the SMEs and MSMEs. So there is a huge gap of corporatization. The solopreneurs are there who have been working. They themselves have been the entrepreneurs and they themselves are the employees of the company. But the moment you have a vision, the moment you have a team which comes in to drive your vision to the next level, that's where you need to improve your corporate structures. And here what we call is, when the private limited is there, the most important benefit is limited liability. That if something goes wrong with the business, your liability as an individual is going to be limited to the capital contribution what you have done. Without that, beyond that, nobody can claim money from you. But if there is a personal guarantee given for any loans which have been taken from bank, then this limited liability concept doesn't work. But otherwise, for the creditors, for the other operational creditors or trade creditors, this limited liability concept works perfectly fine. Most important second thing is when you are raising funds, it's very, very important. Investors have various structures. I mean, you can issue preference shares, convertible preference shares, non-convertible preference shares, so that they don't get into the management, but at the same time, they are shareholders of the company. So these all structuring is possible only in a private limited company, which is usually not possible in the limited liability. And they directly, if somebody is coming and investing LLP, then they directly become a partner. Again, a very important benefit is tax benefit. Now, when we talk of the tax benefit, today, all the private limited companies up to the turnover of 250 crore are under the bracket of 25%. And when we see the individual taxation or LLP taxation, that ranges between 30% to 33%. So the most important benefit, if some entity has to take, is a tax benefit, because of which a lot of companies are converting their traditional proprietor businesses to the private limited company and to avail the tax benefit. And if the company is into manufacturing, the tax rate is even 15%. But again, yes, there are some terms and conditions involved in that as well. So therefore, private limited company is the most preferred form of the entity structure. At the same time, you cannot, if you have more than 200 shareholders, the company will have to be converted to a public limited company. Then there is a restriction on the transfer of shares. Shareholder cannot go and sell the shares to anyone. There has to be first right given to the existing shareholder. This is a protection also. But at the same time, there is a restriction. The shares are not freely transferable. Like today, for example, we go on the stock market and we buy the shares of Infosys. Tomorrow, I don't want it. I have got my profits. I will sell the shares in the open market and I will move out. I don't have to go to the company to get the approval that, okay, I want to transfer the shares. This is my transfer document. Please allow me to transfer. Nothing happens. The shares are freely transferable. But when in the private limited company, the shares are not freely transferable. Means if I have to transfer the shares, I have to prepare the documentation for transfer. I have to go to the company. I have to tell the board of directors that I want to transfer the shares to this person, and these are the documents. We have exchanged the consideration. Now you please approve. And at the time, board has to approve the transfer. So these are some, kind of positives and negatives. And again, limit on raising funds, because when you are into the startup space, you will need multiple layers of funding. So initial layers, definitely investors will come up, but those investors will you always look for the exit. And IPOs, that is initial public offering, getting listed on the exchange is usually the exit route for the investors. Now, when we talk of the compliance, the basic compliances are you need to have your KYC done. I mean, if you have a private limited company, you will be allotted a DIN number. Now you have to do every year compliance of that. There are annual disclosures to be given to the company. So usually what happens is in proprietorship or partnership, me and my company are the same. But when we are talking of a private limited company, I am different, my private limited company is different. So I have to give a declaration to the company that these are the entities in which I am interested, and based on which the auditors of the company decide whether particular transaction is related party transaction or not. So these are the annual disclosures which needs to be given. And when the company has taken has done the transactions with the MSME is medium small enterprises. So MSME, if they have done any transactions, they need to report it to the registrar that these are the outstandings which are due. So these are kind of annual compliances which every company has to do. The next is the annual filing submission, that okay, these are my financial statements. You need to submit it with registrar of companies. And then there is an annual return. So these are very, very important basic compliances which every company needs to do. Now I'll give you the reason, the case wherein 3 lakh directors had missed out on this filing for their companies. And that's where all those 3 lakh directors were disqualified to act as directors for 5 years. So if continuously for 3 years, this kind of returns are not filed, under the company law, it is said that they are disqualified to act as director. And then they have to step down and the company has to appoint another directors. Company in the sense shareholders have to appoint. So I hope you understand the concept of private limited company, wherein the shareholders are different, directors are different, and the management is different. Now, usually in the startup space, we all are the shareholders, we all are the directors, and we all are the management, because we are only people who are executing a lot of things. But over a period, when you grow, the separation, the distinction of the roles has to be very clear, that as a shareholder, what are your rights? As a director, what are your rights and responsibilities? And as executive team, like for example, CEO, the executive directors, the role has to be little different. They get into day-to-day involvement of the business. So non-executive directors usually don't get involved in the business, but they attend board meetings. They give direction to the company. Now, when we talk of the mandatory compliances, every company compulsorily needs to appoint the auditor every 5 years. So every 6th annual general meeting, the auditor is appointed for the period of 5 years. Board meetings have to be conducted. So roughly 4 board meetings have to be conducted in a year. 1 annual general meeting has to be conducted. And these, even though we are a startup, we are a small company, these mandatory requirements under the law, because under the law, there is a small company definition. So if the capital is less than 50 lakhs, the company is classified as a small company. The compliances become little lower, but still these compliances needs to be done. The annual filing is for everyone, whether it is a mid-sized company, small company, or listed company. Every company has to do these kind of compliances. Statutorily, the company has to keep lot of records, which includes your member register, who are the shareholders, directors register, who are the directors of the company. If there are any changes in director, the event-based compliance has to be done. The ROC, Register of Companies, has to be intimated that so-and-so person has resigned from the board, so-and-so person has been appointed on the board. And then there are a lot of registers, register of disclosure. The way I mentioned in the previous slide, that the disclosure has to be given. So this disclosure is usually kept in the register, wherein the auditors can come and inspect that register. So there are around 10 to 12 types of registers which every company needs to maintain. Then there are event-based compliances, like share certificates have to be issued. Most of the companies I've seen, when we do our due diligence for startups, share certificates at the initial stage within 2 months of the company formation have to be issued to all the shareholders. Usually this compliance is missed, and most important thing is, on the share certificate, the stamp duty has to be paid at 0.15%. So these are usual the non-compliances which every company startup space has been missing out a lot of times. And if there is a change in registered office, change in management, senior level management here, it means because KMP, key managerial personnel, like for example, if the capital of the company is more than 5 crore, then they have to appoint a company secretary full time in their company. So if there is a change in KMP, key managerial personnel, managing director, then they have to intimate. Change in capital structure, if there is additional allotment of capital, if the company has taken loan from the bank, the charge is created on the assets of the company and that charge is registered with Registrar of Companies. Again, POSH compliance, that is prevention of sexual harassment, is a mandatory compliance if the startup has more than 10 employees. And not only 10 employees on roll, but even if the contractual employees the company has, they have to follow the POSH compliance. Maintenance of registers and statutory audit. So every year the auditor has to do the compulsory audit of the company, books of accounts. Now, apart from the company law compliances, there are other various compliances also, which includes GST, return filing, quarterly returns, TDS returns have to come in. If the company is sector specific, if the company is into the, say for example, financial industry, BFSI industry, the company will be regulated by RBI, the company will be regulated by SEBI, Securities and Exchange Board of India. So those sectoral compliances also needs to be done. The way I said, you have to file your annual accounts with the Registrar of Companies, you also have to file your tax audit report with the income tax authorities. So these are some basic compliances. I mean, advance tax has to be paid. Filing of the income tax returns has to be there. So these basic compliances, if the company is doing, then the company is more confident. And again, when the investments are coming in the company, the due diligence is given huge thrust. And that's where keeping all these records intact and up to date becomes very, very important for these startups. Now, in this compliance part, if you have any doubt, I will take it up. Otherwise, I'll move to the intellectual property rights.
Yeah, it's clear.
Yeah. So,
ma'am, if the director has resigned in between, so is there any legal liability on that director?
Okay. So basically, if the director has resigned in between, so there is no term for director unless the director is appointed as managing director, for whom usually 5 years term is there. But when the director is appointed, he is appointed till he resigns. So whenever there is a resignation of a director, the intimation, two-way intimation goes to the registrar. One is the director files a DIR 11 which says that, okay, I have resigned in this company. And in turn, he intimates the company. And the company also intimates to registrar that so-and-so director has resigned from our company. Now, as far as liability is concerned, so if I'm resigning today, all the actions of the company done till today, I will be responsible. I cannot say that, okay, I was a director 2 years back, but now I'm not a director. So jo bhi kaam company ne galat hua hai, acha hua hai, I will not be responsible for that. So that usually doesn't happen. If there is a non-compliance, ROC, Registrar of Companies, issues notices to all the directors who were there on that date as a director whenever there is a non-compliance. Even if there are any liabilities, the courts can hold the directors responsible. Along with the company, they can tag those directors into those civil or criminal litigations. So the director from the date, I mean, after the date of resignation, he will not be held liable for anything, whether board approves it or doesn't approve. Because if you have resigned, the board has not accepted, that's perfectly fine. But your resignation has to be intimated to the company, and company should have acknowledged that yes, we have received your intimation. If that is done, after that, the liability doesn't arise. Anything else?
So if in case,
no, ma'am, thank you so much.
Sorry. Yeah. So in case the resignation has come via email and the company has not acknowledged it, then itself it will hold the same value that it's you're looked as resigned still, if they have
Yeah.
not
So
acknowledged it.
usually what happens, yes. So usually what happens is email communication is considered as a valid service of document. If the email has bounced back, then it's a different matter. But if it is not
Absolutely.
bounced back, definitely there are trails to prove. Usually in such cases, the trails also have usually are considered. And if you have an acknowledged receipt of the email that okay, the mail has been delivered to the other person, then there is it is considered as a valid intimation, and based on that printout or the PDF of that email, you can attach it to your resignation, which is called DIR 11, and you can intimate to ROC. So what happens, for example, if there are two directors and one director resigns, now system will not remove that director who has resigned from the system, the MCA portal, because MCA portal will need two directors, and the master data, the director's master data, signatory details will not get affected unless the company has filed the return. So company files DIR 12. So what happens is, if you see your DIN number, against your DIN number, you will see, okay, this company, I was a director and so date I have resigned. But your name will still continue to reflect in the master data of the company, because company has not intimated to the ROC that so-and-so person has resigned. So that continues. Can I move?
Yeah, sure.
Yeah. So when we talk
Ma'am,
of
I had just one question. I'm very sorry.
sure. Go ahead.
So are there any extra compliances for EdTech companies who are working with children from 9 years of age?
Okay, so see, as far as the regulatory compliances with the registrar of companies is concerned, there are no compliances. But when we talk of the EdTech companies, what I understand is there are the privacy norms, when you have created a technology platform, so the data privacy norms, I think these all norms have to be considered
Okay.
when you're going for the compliance. But as far as income tax, as far as GST, as far as the Companies Act is concerned, they don't categorize the business wise compliance, but it is again a sector wise compliance. So if you are a technology platform, then your technology related, what is called which is that law for the
cyber security, ma'am?
Yeah, Cyber Security Act. So
GTPL.
these all laws will be applicable to the EdTech companies.
Okay.
But apart from that, the Companies Act or the Income Tax Act will not categorize the compliance based on that. The intimation, for example, if the company is filing a return, they will classify themselves as EdTech company, the technology company, and that will be taken on record. But apart from that, there is no other specific compliance with respect to that.
Got it. Thank you, ma'am.
Ma'am,
nice.
one small question, ma'am. From where do we find out? Is there any website or anything, any guidelines of the government wherein we can find out what are the compliances for, say, for the education industry, or maybe for the e-commerce industry, whatever it is? Is it sector-wise? It is there, ma'am? Is there anything like that?
I doubt, but there are platforms like shiksha.com and all who give lot of information about the education industry overall, because education industry itself is very wide, which includes the not-for-profit businesses, the societies, the trust in which the big businesses are run, the IITs or IIMs, which are government-led organizations. So every industry will have a different kind of a compliance requirement. So for example, if there is a company, if there is a education society, they are into education, but they are registered as a not-for-profit. So when they are a not-for-profit, the charity commissioner regulations get attracted to them. If that's a society registered under Indian Society Act, or a public trust registered under Bombay Public Trust Act, or any other state regulation, or Indian Trust Act. So that way the sectoral application, the compliances will be triggered to them. Apart from that, I really don't think there is any such kind of a platform which will give you that sector specific compliance. So probably today we all go and just Google, and then all the related information comes to us. So that's how the industry is working.
Thank you, ma'am.
So see, basically when we talk of the corporate identity, why the intellectual property is very, very important. Because when we talk of the creating the brand, the corporate identity, most important part comes is the communication. What communication your brand is showing to the world. what is the philosophy behind the, your identity, how the, whether it is language, whether it is design. So this completely shows a complete corporate identity, the name, the logo, the brand, and that continues and gives you. But now, how do you protect? So I'm sure we all have seen these kind of brands, in the industry today, and the way India is moving towards creating more and more unicorns. Lot of these, companies have been growing massively. At the same time, when, the intellectual property, so when, we call of the IPR. So what is IPR? Intellectual property rights is broadly divided into 5 or 6 categories. The most important part we know is the trademarks. Okay, every company which has created a logo, they will go for a trademark. But when they go for a trademark, apart from that, they also can go under the copyright. So the, the logo cannot be copied. The patents, if there is a process, the manufacturing process or any innovation, in that case, the process is patented. And what I understand is the softwares cannot be patented, but the SOP, if you have a EdTech startup, the process, the flow of the entire platform can be copyrighted, which is, very, very important for every startup to know. Apart from that, if you have again in trademark, there is a trademark and wordmark. So for example, my company name is MentorMyBoard. So MentorMyBoard, what I've done is I've got it, there is a specific logo, I've got it registered under trademark. Apart from that, if I see that below the name of MentorMyBoard, I have a tagline which says nurturing competent directors. So that line, I can go and do the wordmark. So that similar kind of combinations nobody else can use. At the same time, trademark can be a design, the color combination. Wordmark can be purely the words. Those combination of words nobody else can use. When we talk of the copyrights, I'll take that. Now these all are the very important brands what we have seen, and we keep seeing these brands, and they have evolved over a period. Now there have been a lot of litigations also happens when there are intellectual property rights. Like for example, eclairs. Now, eclairs has been, we all know that it was Cadbury eclairs. After 10 years, eclairs, the Cadbury missed out on renewing that brand. And that's where ITC went and registered that brand. So now we even see ITC's eclairs. So it had been a long battle for them. But because they had not renewed, the ITC got chance to use that brand, eclairs, as a trade name. Again, Paytm, PayPal, there have been a lot of such cases which are there. Now, when we talk of the trademark, what are the important advantages of trademark? It gives us an exclusive right on the brand what we are creating, and we can again assign, we can license this brand with the trademark with our the franchise. If you are owning a franchise, you can assign it. And you can earn out of it. If you are collaborating with someone, they can use the brand what you have created, and on the assignment of that brand, you can use, you can charge them a fees or a royalty, what we call, or assignment fees. Again, when in the foreign territories, also the trademark can be registered, which gives the additional advantage. And when the trademark is registered, the symbol is R. But if you just made application, it is not registered. The logo is TM. So if you have seen a brand which says TM, you can say that, okay, this is applied for but not yet approved. But if there is a R, it is approved. And the process, if I tell you, about the trademark. So once, you have created the brand, the logo has been designed, you have to go to the trademark registry. Definitely there are, professionals who keep helping businesses to apply for that. So you have to go and you have to make the application. After the application is made, within a specific time, the trademark registry verifies whatever trademark you have given or applied for, and then they call for the objection. So if they find that, okay, similar name is existing with some kind of other mark, they raise the objection that we have objection that this is not a right, and then you may modify it, or then the application is rejected. Now, if there is no objection, or if there is an objection, there is a hearing given, and you justify that no, there is no similar trademark existing, and they approve it. So after that, that mark is registered, advertised in the trademark journal. Once the trademark journal, it has been advertised, a lot of people will be able to see that, okay, this trademark is newly applied for. And if someone feels that their right is infringed, their trademark is similar to the trademark, so they will be opposing the trademark. And that opposition usually is a costly affair. So, it becomes, a legal battle, because then it takes around 2 to 3 years to either win the trademark or lose the trademark. Therefore, when you are building a startup, getting right name, applying for the trademark, and making sure that it is, sailing through is very, very important at a very initial stage. So disadvantages, as I mentioned, up to 10 years, then after 10 years, you have to renew. And at the same time, you have to show the proof. So for example, if you have not used that word mark, the trademark for a long time, you have taken and registered it in your name, the registry will object and the mark can be taken away. So you have to continuously show the proof at the regular intervals also. The registry keeps the right to ask anyone whether they are using it or not using it. And at the same time, there are 13 plus classes. So one class, the cost is around 9,000 rupees, the government cost. If the company is registered under the MSME, or if the ownership is by an individual, ownership is held by individual, then the cost is half, which is around 4,500 per class. So for example, the class 42, class 35, these are the classes which, are for the consulting business, the training business. I think even class 30 comes under the education, if I'm not mistaken. I don't remember. But there are different 13 different classes under which the trademark can be registered. So the keywords and everything are available. I'll show you the website name also, wherein you can go and identify, are there any similar trademarks existing related to your name, and who owns that, and when that gets expired. So all these things are available on the website. Now, when we talk of the copyright, so usually the authors, the dramatists, the composers, they usually go for the copyrights. I mean, if we have already seen, right? I mean, the literature, and in between also, Sonakshi Sinha, Amitabh Bachchan, they all came and created a campaign of piracy, stop piracy. So that's where the copyright becomes important in those kind of professions. The copyright, the way trademarks are only for 10 years and it can renew, here the copyright is given for the life of the author plus 60 years. So this is something, to protect the right of the person who is actually creating that content. So now, why IPR is important? Again, patent is also similar way. The patent process is little longer. I've not covered here patent because I thought because this was a session for EdTech, and patents are usually not there into the technology business. They're usually more into the manufacturing. If there is an innovation on the part of some the process, the manufacturing process, then usually the patent issues comes up. So now, why IPRs is important is because it contains a very strong valuation. Startup valuation can be decided based on the how many intellectual property rights the startup has created. The IPR can be sold, or the license can be created, and that can be generated. Additional revenues can be generated from it, and if royalties, as I mentioned, royalties can be generated. And a lot of banks also, because if the brands are created, a lot of banks also consider if they're part of the balance sheet, and they are able to show the brand which has been created, the loans also can be given against that. And again, strategic alliances, because if some business has created a brand with that name, the other businesses, I mean, attracting the smaller businesses becomes very easy for the startups. Again, increasing exposure into how today a lot of exposure has gone in copying. A lot of products have come in detection. So if there is any infringement, it becomes, there are, I mean, softwares which detects if there is any copying of the content or not. Piracy is at peak. Injunctions and compensations are like never before. Now, let me tell you, usually, if there is a non-compliance, the law has given the penalty. Okay, if this is a non-compliance, 50,000 penalty. If this is a non-compliance, if you have not filed your return, 100 rupees per day, 200 rupees per day. But here in this case, intellectual property rights, injunctions and compensations are very, very high. Why? Because law doesn't speak about how much compensation you will get if somebody infringes. It's the person who's getting impacted is able to decide the quantum of compensation what he can demand. So this becomes very risky area if the company goes into litigation. If somebody sues the company, the compensation can be very, very high. And the regulators, definitely that has to be proved what loss to the business has been done by use or infringement of the trademark. So that again becomes a legal battle thereafter. Again, most important thing here is why IPRs are important for the startups. If the company or the startup is registered under MSME, there is a refund of the expenses what the startup is incurring. Like for example, you applied in all 13 classes, so 13 into 4,500 is your total cost. So entire cost can be reimbursed by the MSME department. So very few companies are really aware about these kind of benefits which are available for startups. Now, where to apply for these kind of intellectual property rights, copyrights? There is a copyright.gov.in. Again, other industrial designs are there if the company is into manufacturing. So, for example, the bottle of distillery, that has a particular shape. If you remember that the leaf shaped bottle distillery had. So, they all part come under the design part. Lot of, for example, mobile, the Apple mobile. So all these products who have very specific design, the shapes of the bottles, the shapes of the notebooks, lot of times, these all comes under the industrial design if they're going to go into mass production. So they usually protect those designs. And again, geographical indication, like for example, here I'll say, we all know basmati rice, kolhapuri chappal, then hafus, alfonso. So these all are the products which that particular locality manufactures or produces or creates. So to protect them, the clusters, this geographical indications has been introduced. And here government identifies those products and then they assign the geographical tag. So there is a tag also. I think more than 300 tags have been created by government to protect those kind of clusters who are creating like alfonso or hafus is something which lot of people are making and they're using that brand. So they use the GI tag that okay, this is and again there are lot of checks and balances when the government approves this GI tags. So if in the intellectual property rights, if you have any questions, I can take it up. Otherwise, I'll move to the ESOP.
Divya, regarding trademark and copyright, apart from the tenure, like what do you think we should apply, say, for logo or else the name of the company or website, which is more appropriate?
Yeah. So usually the logo, the name of the company, so logo goes under trademark. The name of the company, as it is, if you have, say, for example, applied for example, my company name is MMB Advisors Private Limited. Now, MMB Advisors Private Limited, nobody else can take because Ministry of Corporate Affairs will allow only one MMB Advisors Private Limited to be formed, right? So I'm protected there. Now, if I have a brand, I have a logo of MentorMyBoard, I will go under trademark and register it. Because which will have my color combination, the red, the green, the orange, the blue. So that particular, the font, so that everything, the size of the logo, so that particularly, gets registered under trademark. Now there is a word mark. So if I say MentorMyBoard, this combination nobody else can use. So what I will do is I will go and create or register a word mark in the same class. And let me tell you, if you are registering different the trademark, the word mark, every class, every application is different. So 4,500 multiplied by, you have to keep multiplying that. So if I'm saying that MentorMyBoard, I'm creating a word mark, that will be, nobody will be able to use that particular combination of the words together. So that's word mark, which will have no color, no font, but that's purely the word. I mean, jo likha hai wo. Like for example, in one of the company we created the word mark for them was changing lifestyle. So their company logo with changing lifestyle nobody else can use, right? So they it depends on the word mark what you are applying for. And ideally for the EdTech startup, the trademarks will be very idealistic way of protecting your IPRs. But if you have created a platform and if you have certain specific model, then you can write that entire script, and that script can be copyrighted. So we have seen that the softwares cannot be copyrighted, the protected, because softwares are the code based software. So usually you don't get the protection under that. Anybody can copy the codes if they can. And but what you can do is the flow, the process. Like for example, the if we have seen all Big Boss, so that's a concept. So that entire concept is copyrighted. Nobody can replicate another Big Boss or the Kaun Banega Karodpati exactly same way. So that's the copyright. And again, for the authors, the artists, they have their own art, performing arts. So they can copyright their specific, the lyrics, the tunes, the combination of tunes, they can copyright with their names.
Thank you. It was helpful.
Yeah. Thank you.
One more quick question. I mean, in the type of copyright, for example, we have a process like we are called What is My Goal, where we expose students. The way we do career guidance is different from the regular other people. I want to take an example between Ola and Uber. The only difference is getting an OTP. That is the only difference for now. Like, if we are in a similar situation, like, should we go for a copyright or should we not invest at all in that?
So usually, even if you apply for the copyright, it's if the copyright registry feels that this is a very similar to something which is already existing, they will not allow you to get that process copyrighted. So they will have their own checks and balances to identify the replication. But usually the process can be copyrighted, that's for sure. Now, how different it is, how unique it is, what features are not there in other features, other apps or other platforms, it's purely how you're presenting to the copyright authorities and how they are looking at it, because they also have their own data bank, they also have their own reservoir where they will be able to see whether this is really a different and a unique creation, the process, the SOP, or it is something which has been taken from somewhere. So they have their own checks and balances there. So if they find it, that's a unique one, they will register it.
It was very helpful. Thank you very much.
Yeah, thank you. Okay, so the next point is about the ESOPs. Now, employee stock option plan. This becomes a very important tool in the hands of the employees as well as employers. How it benefits and how it really works. I'll take you through that. Probably next 10-15 minutes we'll spend on this. And then if there are any questions, I would be happy to answer. So employee stock options is something which is called ESOPs, and which are very, very, prominent in the startup space, because to retain good quality talent, you definitely need to pay them very hefty salaries. And if initial stages of the startups, the money flow is less, how do you retain those employees? So ESOP is something which is, if we talk on the legal, the layman terms, it is something that, okay, I'm making you a partner in my company, but the shares which I'm going to allot will not come to you instantly today. It will come over a period of 2 years, 3 years, 4 years, or 5 years. So there is a plan. There is a complete process by which the company also grows, the employee continues with the company, and the employee takes efforts so that the company reaches that level. the valuation and everything. Again, when the shares are issued at a certain price. So that company can keep changing as the board resolution or shareholders resolution. Now, here what happens is, to attract, to encourage and retain employees, these kind of plans are getting created by the companies, the startup space. And what happens is here, the companies grant the option to the employees to acquire the shares. Now, that's a future date at predetermined price. So, after 2 years, you will be given shares at 30 rupees or say 50 rupees. And at that time, हो सकता है company का valuation 500 रुपया हो. So that's the difference which employee benefits whenever there is a ESOP happening. Again, there is no limit on the quantum कि आप कितना दे सकते हो. The 100% capital equity is held by the promoters. Out of that, usually the ESOP pool is created up to 5 or 10% of the total capital of the company. And then out of that pool is kept aside the number of shares, and out of that those shares the employees are given shares. Now, how does it happen? Why ESOP is there? It definitely enhances the job satisfaction because the employees get the ownership of a company and they feel that okay, I am partner in this company. And it also acts as a retirement benefit plan. I've seen lot of companies hire senior people and who initial stage guide to the company, and then after 10 years or 5 years or 10 years they move out of the company because they have already been at a very senior position. They such kind of incentives, ESOPs in the the startup space adds value to the startup to get that the top skill of that entrepreneur, the experience of that entrepreneur or the professional. At the same time, for that professional or entrepreneur, it acts as a retirement benefit. So once they are graduating or they are crossing their 60s and 70s, they are able to get that the shares in their hand, wherein once the company gets listed, the shares can be sold in the market. If the companies are not listed, they can sell the company shares to the other promoters who can buy, and then they can encash those shares. So unless the company is listed, these shares will not be a liquid asset. So what we understand by liquid asset is, tomorrow I want my money. I can go to a market and sell the shares, and within 2 days, so T+2 is the settlement usually happening. So within 2 days I get my money. That's a liquid asset. But unlisted companies, startup companies, these ESOPs are not very, very liquid. Unless the companies have the vision or the plan of getting listed, then that becomes a liquid asset. Now, what are the major terms which are used in the ESOPs? The first thing is grant. When the company decides that okay, we want to come out with the ESOP, they say okay, they create a ESOP plan and they say that okay, we are offering the ESOP option to the employees. That means you are an employee, for example, and the company says okay, you are employee of the company, you qualify based on the criteria, and we give you the offer to apply for the ESOP. Now, the employees will apply for the ESOP and the company will give them the allotment letter, the grant letter. Once the grant letter is given, then the vesting period starts. So this vesting period, the employee continues to work in the company. There is no exchange of transaction. Neither the shares are exchanged nor the employee is giving money to acquire the shares. It's only a letter commitment. Now in this vesting period, so companies say that okay, we have given you an option to purchase the shares, and this option will be, your vesting period will be say 1 year. So that 1 year, nothing happens, right? After 1 year, the employee becomes eligible to exercise the option, right? If within that time, if the employee leaves, it gets squashed. So the employee is not eligible, right? So after the vesting period, which can be 1 year, 2 years, depending upon the cycle of the business. Now, after that, when he is eligible to exercise the option, after the completion of the vesting period, the employee will come and say that, okay, I have served the company for 2 years. Now I am eligible for these shares. So I want to exercise my right to get the shares allotted to me. And at that time, the company calls for a board meeting. The company says so-and-so employees have come. They want to exercise their ESOPs. And now, they have also given the money. So if, for example, it was decided that at 30 rupees, you will get the shares, whether it is 500 at the value at that time of the company, or it is, 10 rupees, the employees, definitely if it is a 10 rupee, companies can revise or rework on the number. And then they say that, okay, please give this money at a discounted rate to the company and the shares are allotted to the employees. A lot of times, again, there is one more option here, which is called sweat equity. So in sweat equity, the consideration is not exchanged. The shares are given for free against the efforts which the promoters or the employees are putting in. So under the company law, initially the sweat equity was not given to the promoters, but for startups, they have a relaxation wherein even promoters are eligible for the ESOPs and the sweat equity. So who all gets covered into the ESOPs? So this ESOP scheme is completely drafted, and the permanent employees of the company, the whole-time directors of the company, non-executive, non-promoter directors of the company gets eligible. Now, permanent employees who have been, on the payroll of the company are qualified. Contractual employees are not considered, to be part of the ESOP. Independent directors are not considered. Directors who are holding more than 10% are not considered. So these are some restrictions which are applicable to listed companies. But for startups, even the consultants can be given the ESOPs. So there are consulting equity also being given. So they also can be the ESOP because it's not listed, governed, regulatory, regulatory provisions are little lesser for startups. They can even give ESOPs to the consultants who are, guiding them in that process. Employees and directors related to promoters, but for the startups, there is an exemption that promoters can apply for the ESOP. Now,
ma'am, small question, ma'am. If you have an ESOP in the company and you have raised the money for the company, so what is the valuation you should be getting and when you should be expecting that valuation?
So see, this is kind of very case to case question. I mean, it's very this situation will change from company to company. If the company has raised the funds, now investors will be monitoring the performance of the company. The in that entire process, the company will be aiming to IPO also. So the actual conversion of the ESOPs to money will happen if the company is going for the IPO, or if some big investor is coming and who is ready to acquire the shares of that employee, and if that employee wants to quit. So then usually the promoters are the people who acquire the shares at the value, and then the valuation has to be determined by the registered valuer. So based on that value, the shares will be exchanged. Otherwise, the usually such kind of shares continue till the company either gets listed on the exchange or some investor is coming and acquiring the shares. Till that time, usually the employees keep continuing to hold. And if in between the employee is exiting the company, then he will be, the promoter will be acquiring the shares definitely. Otherwise, I've seen a lot of companies, even after, exit or the resignation, the employees continue to hold shares in the company.
Yes, ma'am.
I've also seen one startup. So they said, we want to, even give shares to our past employees who were, with the company at the initial phase, but they're now no longer there. But we still want to, make them part of our ESOP plan. So that's also possible because there is no restriction because, the past employees also can be covered because SEBI regulations are not there. If the company is regulated by SEBI, then there are a lot of restrictions which come.
So as a past employee, if you are holding the shares, so your shares are ESOP. So you will continue to get the benefit of that company in the.
You will continue to get the benefit. You will continue to get the benefit, and then you will be treated as a shareholder, the person who is holding shares in a company.
Okay, ma'am. Thank you.
So the silent features, if we say the employees can exercise at the predetermined price, the exercise option is planned subject to the vesting option. So these are, the usual, and I've already, discussed on all these things. The right of disposal of the shares is subject to lock-in. So if, the company has kept a lock-in that, okay, once you exercise, you cannot sell for 1 year. So companies can determine their own terms and conditions to create that plan and how long they want to retain the employees. So the regulatory framework, if I say unlisted Companies Act is concerned and income tax is concerned. So whenever there is a, I'll not go into the taxation aspect of it, but yes, the ESOPs are taxable in the hands of employees. So that amount has to be factored in. When the companies are, where foreign employees are involved, the FEMA regulations also gets covered. And when the companies are listed, while designing the ESOP, the company has to go for, consider CB regulations and income tax regulations, and again insider trading regulations, because employees are also insiders to the company. So this is what the ESOP talks about. I've really broadly considered and considering the time and the topic which Karan had given me. So if there are any specific questions with all the topics, all the 3 topics, I would be happy to answer.
That was a very clear presentation, Divya. Thank you very much. So the question regarding ESOP is, say once my vesting period is over and I'm an employee, I have some ESOPs. Is there a way I can not only give it to my founders, can I sell it to someone else?
I didn't understand.
No, I have few, my company promised me few shares. The vesting period is over. Now I have the right to exercise my ESOP, right? So is it possible for me to exercise not with my company, with an external investor? Or else even with the same case, I'm a founder, I have some shares, not as an actual round, in between the rounds, let's say between my seed and pre-seed round, can I sell my shares to certain investors as a commodity? Is it legal?
You can. If that's part of your, shareholders agreement, because when the different series is going to work, the, shareholders agreement, share purchase agreement will be governing all those, your cap table, how it's, how the shares are flowing from here to there, so that everything will be controlled. And if you have shares as a founder, you can transfer it to the investors.
Perfect. How about the employees? Say they have right now, they have, vesting is over, they have ESOPs, they can exercise it. But in
they
case
can
the founder,
see, right cannot be transferred.
Okay.
So first they will have to get the shares in their name. Once they get the shares in their name, they become shareholders of the company. Okay. And as shareholders, they can transfer to anyone.
Anyone, yes.
Anyone in the sense, again, private limited and startups, there are restrictions on transfer of shares. So it has to be approved by the board. It has to be approved by the investors, if there are investors, because that might be in your reserved matters under the shareholders agreement.
Okay. Perfect.
Ma'am, one question, ma'am. What is the legal implication if the letter has clearly defined, your appointment letter, that you have got an ESOP of so and so amount? So is it applicable, that this can be taken into legal court also, that I was promised but I was not given, if something like that, if some...
Yes. So see, when the company creates the ESOP plan, they pass a special resolution. So once the company has passed a special resolution, created the ESOP plan, that's a conclusive evidence that company has a ESOP. That number one. Now, when the company is giving the appointment letters to the employees, that's a contract which the company is signing between the company and the employees. So if there is a non-compliance to that particular, provision, I mean, the shares are not allotted, the most important, remedy is to take the company into the civil court under the Contract Act. Because the shares are not allotted, you are not a shareholder of a company. You cannot go to the National Company Law Board, the NCLT, National Company Law Tribunal, and drag the company there. So these are the only two courts which usually deal in company matters. I mean, the civil matter or the NCLT, wherein you can get a corporate But if you already holding shares, then you are, if the more than 10%. So even if going to NCLT, you need to hold more than 10%, singly or collectively. So if 100 employees are there who are holding 11% shares, they can go to the NCLT and, drag the company for any non-payments as the employees.
Okay.
But apart from that, these are, very, very kind of informal documents and not very, clear kind of, I can say, a legal structure. Only thing is the company has passed the resolution, filed the resolution with the registrar of companies. So you can always go to the civil court and say that, we are eligible and we have not received the benefit. Like somebody has not received the salary, so and so forth.
Okay. So even if somebody has made in the resolution has made you director, so in that resolution, the equity has to be mentioned in that document along with the thing, or it is not necessary?
No. See, initially, long back, there was a concept of qualification shares, that if somebody wants to be a director, the person should have a share in the company. But after, I think, 2000 Amendment Act, which came in, they removed, I think, the qualification shares. So today, if I tell you, Reliance Industries has, 50 lakh plus shareholders, but only 15 directors. Not necessarily every director will hold shares, and not necessarily every shareholder will be a director.
Okay.
So it's not mandatory that for being a director, you must hold the shares. The company may say that, okay, you hold the shares so that there is a ownership with you, but there is no compulsion under the law that to be a director, you need to hold shares. Like, for example, independent directors, they don't hold shares in the company.
So, but when you will be appointed as a director, and when it is said, then you need to have that thing written in your document, right, ma'am? Suppose you have been made a director and then 5% equity has been given to you, or then it should be mentioned, ma'am, in the document. If it is said during the time of induction, it should be there.
No, you said that first director is appointed and then the shares are getting allotted.
No,
right?
no, ma'am. If the director has been taken during the time of induction, and it is promised that you will become the director, and a resolution is passed, and that with a 10% or 5% or 2% equity, so that should be mentioned on the appointment letter, right?
See, that can be mentioned, but unless the company has followed the process of allotting that 2% or 5% shares, it's not binding.
Okay.
So there has to be shareholders agreement, which has to be there for that matter. And then there has to be a private placement process to be conducted under Companies Act. That you have to open the offer, you have to give the offer letter to the the proposed investor or the director, who then gives the application money. Within 60 days, the company has to receive the application money. So within 60 days of the receipt of money, the company has to allot the shares to that person. So this becomes a process under company law. So if the company is only committing that, okay, I will give you 5%, that doesn't give any binding as such. But if it is bounded by a shareholder agreement, then it can be challenged in the court of law.